Assalamu alaikum and welcome to Digital Amicus. My name is Abdul Hasib Qazi, and today we are going to be discussing the competition law in Pakistan. So recently, after a prolonged litigation of 10 years, the Lahore High Court finally held that the Competition Act 2010, which is the contemporary law that governs the subject of competition in Pakistan, held it to be constitutionally valid. And now we know that the competition law in Pakistan is here to stay. And in that background, we thought it's best to have a discussion with us, Ms. Amber Lakhani. So I'll briefly introduce our guest for today. Ms. Amber Lakhani is an advocate of the High Courts. She has practiced law for over 12 years in Karachi. She obtained her LLB degree from the University of London and later pursued her LLM in jurisprudence and legal theory from University College, London. She has practiced litigation in a broad range of areas, including competition law, company law, constitutional law, property, etc. She has served as a consultant to the Attorney General of Pakistan and is a founding member of the Women Lawyers Association, which is based in Sindh. She is currently also pursuing her PhD from the University of London. Amber, thank you so very much for being with us today.
Thank you for asking. Pleasure.
So if you could start this discussion by understanding what the competition law is and what are some of the salient features of the subject of constitution, and what do we understand by what are some of the concepts that we need to bear in mind when we are talking about competition law?
Okay, so the prevailing law on competition is the Competition Act 2010, as you mentioned, and the object of this law is to regulate anti-competitive behavior. Generally, I'll just give you the in very broad strokes. So it's primarily to regulate anti-competitive behavior and also to actively promote free competition and a free market throughout the country. So the main the underlying concepts that you have to keep in mind when you're interpreting the competition law is that it is when the CCP, which is the Competition Commission of Pakistan, it's the regulatory authority established by this law in order to regulate competition, in order to determine whether, for instance, anyone is engaging in anti-competitive behavior, they have to first establish two things. One of them is the relevant market, and the other is, and it can be in many cases, a dominant position. So the relevant market is a very crucial concept because it is determined with reference to two things. Number one is the product market, which comprises the products and services which are interchangeable with each other. Those defined for instance, if the relevant market, the product market is a cell phone, so then the CCP would look at all the other providers of the same or similar goods in order to determine the product market. The other factor in determining relevant market is the geographic market. And by geographic market, they do not, and this is very important as we discuss the Lahore High Court judgment as well, the geographic market refers to the conditions of competition that are sufficiently homogeneous in a particular area. So it is not determined with reference to the provincial boundaries, for instance, or the area of a city or the area of a town. It is determined with reference to the area within which that product or that particular service which is being considered, what are the conditions of competition relating to that particular product. So it can span provincial boundaries, it can stay within a province's boundaries, it can stay even within a particular, within a locale. So all of these things have to be determined when considering anti-competitive behavior. So there are four major areas of behavior that are regulated by the Competition Commission under the Competition Act. The first one is abuse of dominant position. A company or an undertaking or a group of undertakings may be deemed to have a dominant position if they can if they can act independently of any other competitor or any other supplier, or in fact, or independently of the consumers in the market. So, if an undertakings have market share exceeding 40% in their relevant market, then they are deemed to have a dominant position. So, for instance, any group of companies which may have such a position, if they are suspected of engaging in price fixing behavior, monopolistic behavior, boycotting other competitors, anything that they might be able to do by virtue of their dominant position, that constitutes anti-competitive behavior, and it is subject to penalties and regulation. So that's one instance, that's one area, and it's a very broad. So the manner in which these concepts are defined and these behaviors are defined, it's very, very broad, and they're not mutually exhaustive. So that's one area that's regulated by the Competition Commission. Another area is prohibited agreements. Now, there is a certain non-exhaustive list of agreements that are mentioned in the Competition Act. And again, they're somewhat similar to, abuse of dominant position, but they can exist independently of that. So, for instance, you can have an agreement between two competitors in the same area of the same product, agreeing to divide up the market so as to squeeze out other smaller competitors. Or you can have price fixing agreements, or you can have vertical agreements. There's this concept of horizontal collusive behavior and vertical collusive behavior. So horizontal behavior is, it's between two competitors or two suppliers of the same or similar products or services. Whereas vertical would be, between, say, the manufacturer of a good and the distributor of a good. So because there are different points on the supply chain. So they can, enter into agreements in order to sort of manipulate the price and the supply and demand of a particular product to their advantage. So that's another area. Thirdly, deceptive marketing practices are also regulated by the Competition Commission. Examples of deceptive marketing practices, the most common example would be where one company or undertaking disseminates false or misleading information about another competitor, about some competitor, or it distributes misleading or false information about its own products, or it misrepresents the nature and the quality of its products, and these are determined regardless of the dominant position. So even if a company doesn't have dominant position, but if it's engaging in deceptive marketing practices, it would still be within the ambit of the CCP, regardless of its size. That's deceptive marketing practices. And then fourthly, you have a merger control. Now merger control can be described as more of a preemptive regime, because there are certain types of mergers and acquisitions that, if they meet the pre-merger notification thresholds, which are prescribed in regulations by the Competition Commission. If, for instance, two companies want to combine to create one entity, or one company wants to acquire another entity, and if in either of those two situations, it meets certain thresholds which are specified, for instance, if the combined turnover is going to exceed a certain amount, or if the market share of the acquirer is acquiring more than 10% voting rights, or if the resultant merger is resulting in a combined market share of, say, more than 1/3 of the market. There are different thresholds that are prescribed. So if any of these thresholds are met, then then you have to obtain pre-merger clearance from the Competition Commission. And then the Competition Commission conducts a whole, two-phase process where they first determine whether a dominant position or any lessening of competition is likely to result from such a combination. And if so, then they determine whether such a merger despite lessening competition, is it still in the interests of the economy? Is it still promoting some sort of efficiency? Is it still resulting in some kind of general benefit to the consumers? Because the core issue at the heart, the core principle at the heart of the Competition Act is consumer welfare. It's promotion of competition, but always keeping the welfare of the consumers in mind. So these are the four general areas of regulation of behavior of the Competition Act. And then there are, from time to time, the Competition Commission issues various regulations to further define and to further streamline and explicate all of their activities.
So if you could elaborate on this a little further. So you mentioned 4 incidents which sort of trigger the Competition Act into play. So if we take a holistic view and compare the Competition Act with other laws, such as the income tax law or the sales tax law, for example, which provides how businesses are supposed to conduct their day-to-day transactions, it's ongoing regulatory process. But so would you say that the competition law, given these 4 incidents that you mentioned, is an ongoing regulatory law? or does it only come into play when certain requirements are fulfilled?
No, I wouldn't describe that. I wouldn't describe it as something that regulates the day-to-day affairs of every company,
I see.
or of even most companies, because the manner, as I mean, the Competition Commission's own activities, they extend well beyond these four areas, because they're also involved in, generally monitoring market activities and generally conducting, sort of market research to determine the general state of the economy, of the market, of potential effects of the of governmental behavior, for instance, that might distort competition. But that those activities of the CCP are based on a general on the entire market. They do not regulate or intervene in terms of the day-to-day affairs of any given company. So it's only when, for instance, anyone in any one of these four areas is triggered. So, for instance, if there is any suspicion or any indication of deceptive marketing practices, or of abuse of dominant position, or of any prohibited agreement coming into the knowledge of the CCP, or of course the merger control provisions, which only come into play when there's an acquisition or merger about to happen. So it's only in these four areas that the CCP's regulation with respect to any particular company is triggered. It doesn't, it cannot interfere in the day-to-day activities of the company as such.
So again, a very rudimentary question to understand why we need the competition law in the first place. So if you could explain to us how it actually, how the regulatory framework that's been prescribed by the Competition Act actually, ensures that there is a free market, there is free competition, and in the absence, let's suppose if these laws are not in place, what would be the outcome? Because we also have to take in mind, if you could elaborate on this also, that the Competition Act came in Pakistan very late in 2010. And obviously the market was there all along. So why was it that we realized that we need the competition law in Pakistan, and why did we realize that in 2010?
Okay. So we've had, this is not the first law regulating an anti-competitive behavior that we've had. The first law of that nature that we had was the MRTPO, which is the monopoly, which is the, Prevention of Monopolistic and Trade Restriction Ordinance, 1970.
Okay.
So that was, now the nature and content of the MRTPO is completely different from the current Competition Act. At that point in time, because this is shortly after independence, the concentration of wealth and economic power was concentrated in the hands of a few, of the famous 20 families. So that law, the MRTPO, was brought primarily to sort of tackle that and to break up those, the economic concentration of power and especially of industrial wealth in those few families. So if you look at the preamble and the primary provisions of the MRTPO, the way in which it's phrased is, it basically says there shall be no undue economic concentration of power, and there shall be no monopolies, and there shall be no monopolistic sort of manipulation of the market. So that was basically what that was essentially. First of all, it was a very reactive statute, and it was designed to tackle these specific monopolies, and it wasn't intended to sort of look at consumer welfare in general, or to promote a free market in general. It was focused on breaking up those particular monopolies, which is why the Monopoly Control Authority, which was established under the 1970 ordinance, if you compare the remit of that authority with the CCP today, they're two completely different entities. So the powers that were given to the MCA were very, very limited compared to the CCP today. It did have obviously some powers of inquiry and investigation and imposing penalties, but only with respect to very few behaviors. So you had to, the burden of establishing that there was in fact a monopoly, and that there was in fact like a deliberate collusive behavior going on, the threshold was very high. Whereas now, as we've described, the CCP, the Competition Act 2010, it lays out these very, very broad instances of what may or may not constitute anti-competitive behavior. Because one thing that I don't know if I mentioned is that there are certain types of behavior that are regulated in the Competition Act, and they don't have to be. It's the CCP doesn't have to determine intent, because it says that they may have the object or effect of lessening competition. So even, for instance, if two companies come together to merge into one, and they're doing it with the best of intentions, they're doing it with absolutely no anti-competitive intentions at heart, but if they have the effect of squeezing out other competitors, then the Competition Commission would still nevertheless conclude that this is prohibited. Whereas under the MRTPO, the effect was, the regulatory behavior, the kind of behavior that was regulated was very, very limited, very specific, and there was a high burden to establish that there was actually monopolistic intent. Not intent necessarily, but that there was clear monopolistic behavior going on. So now I would just also like to speak about the constitutional framework very briefly. The Constitution of 1956.
So, Amber, if I'm sorry to interrupt, if we could before discuss the role of the Competition Commission of Pakistan under the Competition Act, and then move towards the constitutional framework.
Okay, sure. All right. Okay. So the MRTPO soon became apparent that it was not suited to the evolving needs of the market of the market of Pakistan. And so what shortly happened after, so there were several reasons that the Monopoly Control Authority was rendered ineffective in terms of dealing with the evolving needs of the economy. First thing was nationalization, because shortly after the promulgation of the ordinance, nationalization happened. It was pursuant to the Economic Reform Order of 1972, and state-owned enterprises were exempt from the application of the MRTPO. So that, and then the nature of the economy had obviously, the market had completely changed because of nationalization. So that was one of the factors that essentially, rendered the MCA toothless in terms of regulating competitive behavior. Anti-competitive behavior. Another reason was that compared to the prevailing CCP, the MCA at that time, the Monopoly Control Authority, did not have the requisite expertise and resources and manpower to actually deal with and respond to market forces and analyze anti-competitive behavior. There was no requirement in law in the MRTPO as such for the members of the MCA to have any particular skills and expertise, as opposed to the Competition Commission right now. And it also again did not have the funds and resources and institutional structure to deal with these issues. So, and then subsequently, when the Corporate Law Authority was under the Companies Ordinance was established, some of the functions of the Monopoly Control Authority were subsumed within the Corporate Law Authority, and it was made a department. And there was generally a policy of, generally speaking, either because there was no governmental will, or because there were inadequate resources, for a whole host of reasons, the Monopoly Control Authority was not very active in actually pursuing its functions and actually monitoring, monopolistic behavior. So it remained largely more or less defunct for a very long time. Now, in the 90s, as we know, privatization started in the late 80s and 90s. The liberalization of the economy started happening. Privatization started happening, and so over the next, couple of decades, the economy started to evolve rapidly. And that's when, I think around in the early 2000s, it became apparent that the country needed a clear and sophisticated framework in terms of dealing with competition, in terms of dealing with competitive behavior that was in line with international practices, which is why, the World Bank was engaged to assist our legislature in drafting a law that was in line with the UN laws, that was in line with the EU laws, that was in line with the international treaties that Pakistan has been a signatory to from time to time. And then eventually, out of that entire process, the Competition Ordinance 2007 evolved. So that's how we ended up with the 2007 ordinance. And then subsequently, there was a 2009 ordinance, and then the 2010 Act. And essentially, substantially, the 2010 Act is identical to the earlier ordinances. There are some minor differences in terms of the penalties being raised, mostly, but within substance is the same. So that is how we ended up with the prevailing framework.
That's how the Competition Act 2010 evolved. That was the evolution. Okay. So if we talk about the role of the Competition Commission of Pakistan,
Right.
So if you could explain how, what is the mandate of the Competition Commission under the Competition Act, and how does it regulate? What are some of its activities? What are the powers, and what is the role of the Competition Commission to regulate the competition and the competitive, and to stop anti-competitive practices in the market?
Right. So, in addition to regulating the four major areas of behavior that I described earlier, excuse me, the Competition Commission has, so like I said earlier, it's the remit of the CCP is not just to respond to potential anti-competitive behavior as and when it's happening. Its role is its responsibility is to also anticipate anything that might happen in the future. So for instance, one of the things that one of its functions is to monitor market conditions on a very regular basis. There's a particular wing, I believe it's called the Research and Policy Department of the Competition Commission, whose primary function is to conduct research and generate reports and generate data on a day-to-day basis about the nature of market conditions in different sectors, and what kind of sort of where the market is headed, what kind of factors might be inhibiting entry for new competitors in the future, and what kind of governmental interventions might help, or what kind of governmental actions might actually impede entry, things like that. So it's not just to respond to potential anti-competitive behavior as and when it happens. It's the role of the CCP is to promote competition by engaging in a vast range of activities, which include research, which include monitoring, which include conducting competition training and awareness campaigns at various different governmental levels. So and it has been if you just glance through the recent orders passed by the CCP, which are published on their website on a regular basis, it is probably one of the most proactive regulatory authorities in the country, and it's actively going after every sector: the banking sector, the telecom sector, petroleum, oil, gas, sugar, and cement. It's been quite proactive.
So as a student of law, I'd like to understand what the Competition Commission eventually does. Say there's a violation of one of the provisions of the Competition Act, or one of the four incidents that you discussed in the beginning occur.
Yeah.
So in that case, what does the competition do? They pass an order, and if there is an aggrieved party, let's say there is a business entity that's aggrieved by the order of the Competition Commission, what follows?
Right. Okay. So generally, the Competition Commission also has a power to conduct inquiries, right? So where it may suspect that there might be some kind of, by looking at market conditions, for instance, in the cement sector, it might suspect that there is some kind of anti-competitive practice going on at a large level. It would then issue a notice, a show cause notice. So generally speaking, there is a show cause notice, there is a hearing, and obviously the hearing has to comply with the rules of the principles of natural justice and due process. It cannot pass an order without giving a fair and proper hearing to the parties that are concerned. So, and if after conducting that entire hearing it concludes that there has been a violation of any one or more provisions of the Competition Act by any undertakings, then it will issue an order to that effect.
Okay.
And impose. And so now, when it comes to issuing an order, there is a range of actions that the CCP can take. One is they can impose a penalty. They can impose a penalty of extra fees, and the various provisions of the Competition Act as well as the regulations, they provide for different maximum penalties for different sorts of violations. So for abuse of dominant position, a certain amount, depending on the turnover, for instance, of the companies that are involved. And there will be different penalties for different violations. What it can also do in addition to, or as an alternate to imposing penalties, is it can require the offending undertakings to restore the market conditions that existed prior to their collusive behavior or prior to their anti-competitive behavior. So it can, for instance, if there is a merger that's resulted in, lessening of competition, it can order us, the splitting up of that entity. If there is, if there is an usually though, that's something that has to happen when at the prior to the CCP even granting pre-merger clearance. But it's subsequently, if it finds that if a particular merger was given approval but it had the effect doing so, it can do that. So these are just some examples of the actions that the CCP can take. There are certain types of actions that constitute criminal offences as well under the Competition Act,
I see.
and in those cases, then the Competition Commission can institute criminal proceedings against the offending entity in a court of competent jurisdiction. So these are the different types of actions undertaken. Now, as far as remedies against the CCP's orders are concerned, the first appeal lies, but this is only now. So there are two kinds of orders that can be passed. There are certain types of orders that the Commission as an entity has to pass, is empowered to pass. And then there are certain types of actions limited, much more limited. There's certain types of orders which one member or one or more members of the Competition Commission can pass. So as far as orders of the members are concerned, there is a right of appeal before the CCP's appellate bench. But that appellate bench is a part of the CCP itself. It doesn't exist independently. As far as orders of the CCP itself are concerned, so for instance, where the CCP finds that a telecom company has engaged in abuse of dominant position and passes a detailed order, then against that order, an appeal would lie to the Competition Appellate Tribunal. Now, the tribunal is it's an independent tribunal constituted under Section 43 of the Competition Act. And,
which is independent of the Commission.
Which is independent of which is supposed to be independent of the CCP, and it's supposed to have a chairperson and who is the judicial member, and then two technical members who have the requisite qualifications in in the relevant area, whether it's industrial knowledge or economic expertise. The various different types of requirements and qualifications have been specified. So the Competition Appellate Tribunal is the forum for challenging orders of the CCP, and any order of the CAT, which is a Competition Appellate Tribunal, can then be challenged before the Supreme Court of Pakistan, which is the final appellate authority under the.
And the high courts do not have jurisdiction.
The high courts do not have jurisdiction, not under the CCP Act. There's one thing I should clarify. The Competition Act doesn't confer jurisdiction on the high courts, but obviously under Article 199 of the Constitution, the high courts exercise
constitutional jurisdiction. So now if we could move towards a different tangent and move towards the litigation that was before the Lahore High Court. Now, we also know that you were there representing and defending the competition, representing the government and defending the Competition Act 2010, and successfully so. So if you could tell us what the litigation before the Lahore High Court was about that challenged the vires of the Competition Act. What were some of the issues that came under challenge before the Lahore High Court, and what was ultimately held by the Lahore High Court? This obviously includes the legislative competence of the parliament, which you mentioned briefly earlier.
Yes. Okay. So just a brief clarification. I wasn't directly representing any entity. I was only assisting the Attorney General. So the primary issues involved in the litigation before the Lahore High Court were, first of all, there was a large number of petitions that have been pending for several years, going back to 2007. And all the petitioners hailed from different sectors, from the telecom sector, from the oil and gas sector, from cement sector, different sectors. So all of these petitions involved, roughly speaking, 3 or 4 main questions of law. So the first question, and probably the most important question, was, does Parliament have the legislative competence to enact the competition laws? And the laws that were under challenge were all 3 laws: Competition Ordinance 2007, 2009, and Competition Act 2010. The reason being that many of the show cause notices that were challenged by the petitioner companies had been issued under the 2007 ordinance or the 2009 ordinance, as well as the 2010 Act, because this litigation had been going on for a while, like I said. So the first question was, does Parliament have competence to legislate in the area of competition? And in addition to that, the petitioners also challenged the fact that their claim was that the CCP and the Competition Appellate Tribunal are basically performing judicial functions and are therefore, violative of the Constitution, specifically Articles 175 and 212, because the Constitution provides for a free and independent judiciary, which must be separate from the executive. And the allegation of the petitioners was that the competition, basically these competition laws, they purported to confer judicial power powers on these two authorities. So that was another ground of challenge. The third ground of challenge was that the High Court was also a violation of Article 175, or was also a violation of the Constitution. According to them, the Supreme Court's jurisdiction could only be, exercised in accordance with what was already provided under the Constitution. And finally, they had challenged the various validation provisions under all three laws, which provided for the continuation of these three laws during the gap period. So I think the most substantial part of the judgment relates to the first one, the first ground of challenge, which was, can Parliament legislate on the area of competition at all? So, in determining this question, the court, it's sort of traced the historical development of competition laws in general in Pakistan, and it started by looking at the very first constitution, which was a '56 constitution. And so, interestingly enough, it was only the 1956 constitution that had a specific entry, a specific legislative entry on the subject of competition, right? So, as you must be aware, as students of the law and constitution, currently there is only the federal list in the 1973 constitution post 18th amendment, right? Prior to the 18th amendment, we had a federal list and a concurrent list. The federal list covers subjects that are within parliament's domain. Concurrent list used to have subjects that were within concurrently within the federations and the provinces domain. And now post 18th amendment, the concurrent list has been deleted, and you just have the federal list and residuary powers, which means anything that is not on the list is supposed to fall within the province's domain. So, but when the '56 constitution was there, so this was something that was on the concurrent list. The entry 10 relating to competition fell within the concurrent jurisdiction of both federation and provinces. But at that time, no law was enacted pursuant to this. Then in the '62 constitution, which was relevant for the MRTPO, that entry was removed, but the federation had exclusive power, and it was a very broad discretionary power. It was under Article 131(2), I believe, where they could, if they determined it in the national interest and to promote, sort of, I think the words were economic and financial planning and coordination, they could legislate exclusively in the national interest in relation to such areas. And while the word competition was not specifically used, it was in pursuance of this power that the MRTPO was promulgated in 1970, which is the Monopolies and Restrictive Trade Practices Ordinance. So it was in pursuance of this federal power to legislate in the national interest to provide for, to promote national financial and economic planning and coordination. So this is something that the court picked up on, because the petitioner's argument was that, we in the '56 constitution, entry 10 existed, and in the '62 constitution, this Article 131 existed, which is why the federation could legislate. So they admitted that. And then their argument obviously was that, both of these things were removed in the '73 constitution. And therefore their argument was that this power therefore fell to the provinces. So the court said that, the fact that you yourself have admitted that under the 1962 constitution, this, the regulation of competition and the promotion of a free market was something of national interest, even back then in 1970. And therefore it must be, it indicates that it continues to be a matter of national importance, and it continues to be something that the federation can legislate. So that was the starting point. And then there were a range of other, provisions of the constitution that the court relied on in determining that Parliament did in fact have a legislative competence. So primarily, I'll just lay these out very quickly. First of all, Article 18 of the Constitution provides that, so every person has a right to conduct free trade and business. However, such right is subject to the state's authority to regulate business in the interest of promoting free competition. I'm paraphrasing very loosely here. So Article 18 essentially obligates the state to promote free competition and to regulate businesses and trade in the interest of promoting competition. So first, the court said that you have to recognize that the state is under an obligation to promote free competition and to regulate businesses and trade to that effect. And This interest, and very importantly, the court held after looking at two recent judgments, one of them is 2020 SCMR 1, that after the passing of the 18th Amendment, this obligation of the state, of the federal government, to ensure the protection of fundamental rights has not been taken away. Has not, so where applicable, where, for instance, the provinces cannot effectively legislate in order to protect certain fundamental rights, the federation is empowered, and is not only empowered, it is obligated to do so. So, and in doing so, the court relied on, a recent judgment, Sui Southern Gas. I believe, it's 2018 SCMR 802, where a very similar issue had come up. In that case, the legality of the Industrial Relations Act 2012 had, I think it was 2012, had been challenged because the IRA 2012 provided for the establishment of trans-provincial trade unions. And this was for, it was for the establishment of trade unions for those companies which were trans-provincial in nature, meaning where, their businesses and their activities transcended the boundaries of any one province. And it was held that, this is now the right to unionize is something that's protected under the Constitution. And the Supreme Court held that this is something that any individual province, in the case of trans-provincial companies, the provinces could not legislate. Obviously, as far as companies that are concerned that are solely, strictly within the ambit of one province are concerned, the provinces can effectively, regulate trade unions. But as far as trans-provincial companies are concerned, for instance, Sui Southern, K Electric, various other companies, Unilever, whichever. So as far as those companies are concerned, the workers must be allowed to organize trade unions at a trans-provincial level, at a federal level. And it was for those companies that the IRA was enacted. And it was ultimately, the Sui Southern case for the Supreme Court, which was decided in 2018, it was held that even though there was no specific legislative entry in the fourth schedule relating to trans-provincial trade unions, nevertheless, reading, the fundamental rights together with entries 58 and 59, which provide for, general matters relating to the federation, reading those together, the court held that the federation did in fact have legislative competence. So something very similar, a very similar process of reasoning was, it unfolded over here. So the court held that even though, yes, there is no specific entry relating to competition in the fourth schedule in the federal list, nevertheless, looking at Article 18, which obligates the state to promote free competition, read with entry 58, which empowers a state to the federal government to legislate on matters which relate to the federation. And in particular, there was a great deal of discussion on Article 151. That was actually one of the cornerstones of this judgment. So Article 151 deals with interprovincial trade and commerce. Yeah. And as far as the judgment is concerned, I think the most important provision was Article 151 subsection 1 or subarticle 1, which says that trade, commerce, and intercourse throughout Pakistan shall be free. And the majority judgment especially, gave a very, very purposive and liberal interpretation to this particular provision. And it said that, this provision, which says that trade, commerce, and intercourse throughout Pakistan shall be free, it envisages a single national economy and a single economic unit, a single free market throughout the country, right? So, and in order for trade, commerce, and in order for competition to be promoted, this is a prerequisite that must be met, because it's, for instance, if the country because Pakistan is a federation, right? So the principle of federalism was applied, and the court said that if the market was to be split up on a provincial basis, there could be competing and contradictory regimes in each province, and this is something that's using just general knowledge of the market and common sense principles. It's not difficult to imagine a situation arising where Sindh legislates on competition and imposes very strict regulations, for instance, just hypothetically, whereas Punjab passes its own legislation and has a completely different standard for determining competition, right? So naturally, even in the presence of two laws, you can very easily imagine that there would be a very difficult situation, and it would, in fact, not only would it not lessen competition, it might promote anti-competitive behavior, because companies might be incentivized to, locate their activities in a province where they think there is a more relaxed regime, and the regulatory structure is not that strong, as opposed to, another province where it is stronger. So it was, it was in light of these principles and the nature and purpose of Article 151 that the court eventually held that the intent of the framers and the intent of the constitution is such that, because the federation is obligated to promote a single national economy and promote free competition throughout that economy, it is the federation's job to do so. And it was also briefly, and there was also a lot of discussion around the fact that by its very nature, by its very nature, the subject of competition is such that it's in order to effectively regulate it, especially in today's economy, it has to be something that the federation regulates. Because, like I said, if it were left entirely up to the provinces, then there would be different competing contradictory regimes. And this reflects,
So basically, one can't imagine the subject of competition to be provincial. It's just not
yes.
practical.
I mean, just given market conditions, it's so now it's interestingly, the Justice Aisha Malik, she wrote the majority judgment.
Yes.
She said that that Parliament can not only legislate, but that Parliament can legislate on competition across the country, not just in the case of trans-provincial companies, but all companies across the country, because that is how the economic framework of the country is envisaged under Article 151. But she held that the question of whether provinces could also legislate, she held that that question was not before the court, and so she declined to decide that. However, the remaining two judges differed with her on this ratio, and what they held as far as Parliament's competence was concerned was Justice Shahid Jameel wrote a dissenting opinion, and Justice
I think it would be safe to call it a separate opinion.
It was definitely a separate. So he concurred with her on two issues, but as far as Parliament's legislative competence is concerned, and as far as the parallel judicial framework, which I'll come to shortly, is concerned, he dissented. So as far as legislative competence was concerned, he held that his lordship held that the Competition Act was validly enacted, and that Parliament did have competence to legislate. However, Parliament's competence to legislate was limited to only those acts of anti-competitive behavior which had an impact on the national economy and therefore on interprovincial trade and commerce. So his lordship, he deferred, and he said that that from here on, the Competition Commission, whenever it takes any action pursuant to its powers under the Competition Act, it must specify that the anti-competitive behavior that is being regulated has an effect or has an impact on the national economy or on interprovincial trade and commerce. So he
spillover,
sort of,
if that's the right
exactly, he applied the spillover doctrine. So his idea was that Article 151 empowers, read with Article 18, empowers Parliament to do so, but he 151 as opposed to Justice Aisha Malik, and Justice Sethi simply he concurred with that. So I think like it still has, nevertheless, it has far-reaching consequences for constitutional law in future, because it's a very, very good judgment on it's a very, very
Indeed.
good illuminating discussion on what defines, and there was I'm giving you a very brief summary, of course, because of time constraints, but it's a very extensive discussion on constitutional interpretation, on what principles apply when determining the legislative fields of both Parliament and provinces, on the nature of competition, on the US regime on competition under the Interstate Commerce Clause, and there's a very interesting chain of jurisprudence under the Commerce Clause as well. So, and a lot of these things had come up during arguments as well. So that's why it's much of it is still fresh in my mind. And there was a lot of discussion on the US Commerce Clause. It is very interesting. and if we'd had more time, I would have gone into that as well. So that was as far as the legislative
Maybe when the
competence.
judgment goes to the Supreme Court, we'll have you for another session.
So that was as far as the legislative competence was concerned. Then the second main area was the argument regarding the creation of a parallel judicial system.
Okay.
Now the petitioner's claim, just to recap, was that the CCP was conducting judicial functions, and the Competition Appellate Tribunal was also conducting judicial functions, and therefore this amounted to a violation of the Constitution, because under the Constitution, the judiciary must be independent, and under Article 203, subordinate courts are subject to the jurisdiction of the High Court, whereas here the High Court was completely taken out of the equation. Now, Justice Aisha Malik, again in minority, held that neither the CCP nor the CAT was conducting judicial functions as such. So she went into a detailed discussion of the difference between judicial functions and quasi-judicial functions and regulatory functions. And her opinion was that the CCP and even the CAT by extension, they were essentially carrying out regulatory functions, because the Act established the CCP as a regulator. It conferred a vast range of regulatory functions. And she said that, yes, in the discharge of these regulatory functions, certain judicial functions were being performed by the CCP. However, these did not form the primary function of the CCP. And she applied various different, there's a whole chain of case law regarding what constitutes judicial functions from the Supreme Court. And she applied a number of different tests. One of them being primarily, the purpose of the establishment of a forum. So the purpose of for which a forum has been established is one of the key factors to be looked at in determining whether it's carrying out judicial functions. And so, she held ultimately that the CCP was essentially established as a regulator, and while in the discharge of its regulatory functions, it might be from time to time called upon to perform judicial functions, that does not mean that it was a judicial body or a court under the framework of the Constitution. And so she said that essentially the role of the CCP was to restore competition, and not that was her reasoning. So, and she said, and then she also went on to hold that the Competition Appellate Tribunal was essentially an extension of what the CCP was doing, in that even though obviously its power its jurisdiction was very limited, but she held that because the CAT's jurisdiction was limited to adjudicating appeals on the CCP's orders, essentially the purpose of the CAT was also the same, which was to restore competition and curb anti-competitive behavior. So her opinion was that both of these are not conducting judicial functions, and therefore, they don't fall foul of the Constitution. As far as the CCP was concerned, the remaining two judges concurred with her. They held that the CCP itself is a regulatory authority and not conducting judicial functions. However, as far as the Competition Appellate Tribunal is concerned, they dissented, and or rather, they were in the majority as far as the CAT status was concerned. And Justice Shai Jamil wrote a short dissent in which he interpreted the same line of judgments differently, and he held that the CAT was performing judicial functions because the purpose of the CAT was to conduct adjudications on on the orders of the CCP. So it's very interesting also because they looked at essentially the same historical jurisprudence on this area, but they both reached very, very different conclusions. And Justice Shai Jamil Saab, he looked at, in addition to the purpose for which the forum was created, he also looked at the manner in which it functioned, the manner in which it adjudicated rights and liabilities, looked at evidence, things like that. And so he concluded that the CAT was indeed a court, and it was therefore required to be, established and brought in conformity with the provisions of the Constitution. Now, he decided his position on the CAT with respect to a leading judgment of the Supreme Court. It's the Sheikh Riaz al-Haq judgment. It's 2013 Supreme Court. And so in that judgment, the legality or constitutionality of the service tribunals was at play. and the decision in that judgment was that, in the appointment of members and the appointment of the judicial members of the service tribunal had to be done in accordance with the Chief Justice of the Pakistan in the case of Federal Service Tribunal, and the Chief Justice of the concerned high courts in the case of the provincial service tribunals. So so Justice Shah Jamil essentially said that, the same principles shall apply to the appointment of the members of the Competition Appellate Tribunal. And his decision was that the federal government would have 60 days to bring the appointments and as well as the financial terms and conditions of the Competition Appellate Tribunal, and that the government would have 60 days to bring it in line with the principles enunciated in the Sheikh Riazul Haq case. And that is something that has been acknowledged by the CCP. As far as I think when I last checked, it has not been done as yet, as far as the current news update is concerned. But that is, I'll have to check that. But the last time I checked, that has not been done as yet, even though 2 months have lapsed. And finally, regarding the appeal, the power of appeal to Supreme Court, the petitioners argued that this was violative of the Constitution because the Supreme Court's jurisdiction can only be such as is specifically laid out in the Constitution. And on this point, all three judges unanimously disagreed. They said that because Article 175(2) very clearly says that the courts under the Constitution shall have, the courts shall have such jurisdiction as is prescribed under the Constitution or under any other law. And so the Lahore High Court was very clear that the words "under any other law" clearly mean that the Parliament has the power to enlarge the jurisdiction of the Supreme Court, and it has in fact done so from time to time. For instance, under the Ogra Ordinance, the power of appeal goes directly to the final appeal lies directly before the Supreme Court. So, and here too, it was held to be valid. So on that ground, the petitions were, unanimously dismissed. So I think that pretty much sums up the judgment.
Yes, it does. Thank you so very much, Amber, for being with us today. Thank you so very much for enlightening us about the competition law in Pakistan, its procedure, the role and mandate of the Competition Commission, and what happened before the Lahore High Court, and explaining to us the judgment of Justice Aisha Malik of the Lahore High Court, holding that the Competition Act 2010 was intra vires of the Constitution, that it was constitutionally valid. So thank you so very much. We would probably, it would be an honor to have you with us again if this judgment lands in the Supreme Court in appeal. So thank you so very much for being with us today.
Thank you so much for asking me. This was a pleasure. A lot of fun. Thank you.
Thank you so very much.
Okay.